Sequino. Good afternoon.
Good afternoon.
Please raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat.
Thank you.
Welcome.
Thank you, and welcome, and thank you for having me here today. Senator McDonald, Representative Lawler, I thank the Governor for giving me the opportunity to return in front of you and the opportunity to hopefully serve for another 8 years. Presently now I am a senior judge, and that means, as you've heard, that I have been a judge for over 20 years and have chosen to continue to work as a senior judge for the balance of time. Since I was here last, let's see, I've been a judge also since the fall of 1985. My first term would have been March of 1986, and so it's been more than 24 years. I became a senior judge in April of 2006, so just over 20 years after I was on the bench. I have continued in that time and appreciate the opportunity as a senior judge both to continue to work and to have more flexibility and choice in my assignments and in my location. So I have been basically between New Haven and Milford and Derby over the past 8 years. And I am here to speak for the GAs, the geographical areas. That is where my heart is. That is where despite my civil and educational background, that is where I choose to work every day. It is hopefully my area of expertise. And I am a strong advocate, I would hope, for the geographical area courts, although I certainly understand that there are other areas that need your attention and need your review, and certainly everyone is competing for limited resources. I believe that we serve in the court system, and to the extent the court system is looked at as a social service agency, not a criminal justice agency, this is where we serve the vast number of people who come in front of us every day. And thank you.
Thank you very much. Are there any questions? Senator Kissel.
Thank you very much. One of the things that folks that need to get up to speed in trying cases, I recall back when I first passed the bar 26 years ago, that the GAs were where you could actually perhaps try a case that may not have been monumental. And indeed, I actually went through that process myself. But right now, it almost seems like the GAs, they move business, and things settle out rather than ever really coming to trial. And so there's not really that sort of forum where attorneys can build up their experience in the courts. And I'm just wondering what your observations are regarding that.
I don't believe it's one of the objectives of the criminal justice system to give lawyers experience, although they should have it. You will find that your younger lawyers are getting those experiences in the cases that do go to trial. Quite unfortunately are the cases with the mandatory penalties. You'll see more driving under the influence cases or driving under suspension due to an alcohol-related offense because of the mandatory penalties than you're going to see great cases of guilt or innocence in the geographical area court. I don't think there's anything objectionable about parties reaching a plea agreement. Any type of situation or case where two parties come together and resolve their differences, make their choice, know what they're facing, is a far better resolution than when they leave it up to me, a third party, a stranger. Now, for the parties, the cases that have to be tried, we have to be available for them. We need courtrooms, we need staff, we need all of that support system that would be there to give the parties their day in court and the attorneys their experience. But trying cases for the sake of trying cases, we don't have that luxury, nor is that necessarily a goal.
And my other question is the impact of the recession both on the cases that are coming before you as well as the system that you operate under.
The cases I think that Judge Damiani mentioned it, the number of people with no prior record, and I believe this starts with young people. Perhaps it's more devastating when it does. That they are stealing from their employers, or not realizing that that first job as a clerk, that they aren't supposed to be writing a gift card to themselves every 3 days, or the bookkeeper that might have worked without problem for years, starting to write themselves checks or expense accounts. There's so many ways that that is happening. You certainly see it in the shoplifting. You see it in the all areas of court. You also will see it in increase of any crimes. One that isn't mentioned here, and again, we talk for the common man or the lowest common denominator, is motor vehicle, registration, insurance, and all the impact. Having those proper marker, those are criminal offenses, carry a jail term, end up in front of a GA judge with the marshal and with the staff and all the panoply of services that has to be devoted towards those cases, and the multiple repeat under suspension. The number of times that we spend, we let people get their licenses back. I mean, my system is so long as you make progress, you can have as long as you need if you don't drive and you make progress. In any court that I've sat in, any fee that I could waive could always be done automatically with community service. Just straight up front, do it up front. Any fee can be waived if you do community service. I don't ask questions. I can't do that for motor vehicle. But other issues such as that. So to make that system so that people can have their license, get to work. Any continuance in a court case takes people away from their jobs or their ability to look for a job or their need for a babysitter. There are so many areas where we make an action and it has a reaction, and then unfortunately it may not be the intended consequence. So you are going to see, and it may not make the headlines, but if you want to see a place where the first place the economy is going to strike, it's going to be in your motor vehicle issues. Not going to court, not paying your ticket, not keeping your registration or your insurance up. We're going to pay for that down the road in terms of our trials and our system. And like any other problem, we can't pay that fee for someone. But we do have to understand that every action, every fee, every penalty, every criminal penalty where we try and make the penalty control behavior, there are going to be cases where it is not working necessarily, and it's just going to expand our business and therefore increase our expenses.
Am I hearing in that answer that perhaps we should consider allowing the courts, the judges, more latitude in waiving motor vehicle fines and imposing something like community service? I mean, if it's used in one area, are you saying that it might be helpful in another area?
I think judges have that ability to do that. I don't think and prosecutors will do that without coming to judges or making contributions. I don't think that is a system that needs to be changed. I think that it could be spread. We could come up with uniform procedures so that when you do come into a court, no matter what court you go into in the state, you know what the procedure is. It's going to be the same. As you talked about, I think you talked about going to speak with the prosecutor. I unfortunately had a youthful offender don't get summoned to come until 2 o'clock, sitting there with the mother. Of course, it's their first time in court. They didn't know they were supposed to go talk to a prosecutor. And the prosecutor's saying, well, no one came to talk to us. And when you're sitting here, they don't know to go to talk to you because, God bless, they've never been arrested before. And there are some things that when you work in a system and you take for granted, as you say, the first person that comes into the system, the newcomer, doesn't even know that basic a way the system works, which is you go, if you don't have a lawyer, you talk to the prosecutor. And that created a continuance. We had to continue the case and explain to the parties. So but those are good things that happen, that when you learn that people haven't been arrested before and you can then help them through the process. So I don't think that's a criticism. It's just something you have to be aware of. We get used to our process and our procedures, but you have to treat the people coming in front of you every day as if this is their first time there.
I appreciate that answer, and I think it's very helpful. And the whole notion that someone might not understand that they have to go and talk to the state's attorney, I understand that completely. I mean, to be honest, back when I was doing a lot more court work, each individual court sort of had their own nuances. You know, I mean, if you didn't know to get in the right line over in Rockville, you could be spinning your wheels,
That's right.
depending on which floor.
Which is motor
you know,
vehicle.
and Manchester was a whole different ballgame, how that whole was operated, and Enfield was different, and GA14 was different. And so that's just the lay of the land, and that's for someone who's supposed to know what, you know, like you pass the bar, you're supposed to know all of that intuitively, but there's definitely a learning curve, and for the members of the general public, that's very difficult as well. I really appreciate your answers. I think that it offers us some insights as to what we need to pay attention to, and I wish you the very best of luck.
Thank you.
Thank you, Mr. Chairman.
Anything further, Senator Gomes?
Good evening.
Good evening, Senator.
I just have a couple of questions based on your complaints that were filed against you. There were 4 complaints filed against you, and 3 of these complaints were considered by the council and were determined to be time-barred. These complaints, therefore, were dismissed. And the only reason why I'd like maybe that you'd allude to some of them, what really happened here, because being time barred, you get no explanation of whether they were true or not. And some of the complaints that were issued, like one says wrongful imprisonment here. Another one says violation of due process. And the third one was prejudicial conduct and decision, which, if they were true, would be pretty serious charges. Being time barred, we have no way of knowing. I'm not going to say they were true. I'd just like to hear about them.
Well, actually, the first one, is it hard to be proud of being complained? I don't know. But Addison, I believe it's Addison Beddings, or it could be his twin brother, who believed I commented on his guilt. He and his brother, and I don't know which one was the husband or wife, killed Vonda Bennings. And previously, I had had the husband and the brother both in front of me for a prior incident where the first domestic violence arrest, it had been nollied. It had been dropped. And they came in front of me, and I don't recall if he had a lawyer at that point in time or not. And his wife was pleading for the mercy and asking, begging, pleading for a dismissal of the case when the prosecutor had seen fit to nolly it. I refused to dismiss that case. I thought that was some protection. I said he could take the family violence education program and he could earn his dismissal, but that there had been probable cause to sustain the arrest, and if he wanted a dismissal, he had to take the family violence education program or accept the nolly, which, as you might know, the prosecutor has sole discretion over. I believe they accepted the nolly. I don't know if that generated the complaint or a later comment on bond when he was incarcerated after he allegedly and his brother murdered his wife. But I don't know if that was time barred. It was because of the passage of time.
No, this one
my
wasn't
prior
time-barred.
knowledge. He would have been one of the ones that was time barred. I believe the only one that wasn't time barred was dismissed. Mr. Bennings was time barred, but quite
This is the
frankly,
one-
I
this-
would have been delighted to have the opportunity to review those transcripts and to respond if there had been probable cause to determine there was a violation. Unfortunately, the time bar, you don't even get the benefit of them determining whether or not there was a violation.
Well, Addison Benning was the one the only one that
all right.
wasn't time barred.
All right.
It said he had a failure to reduce bond and made comment about guilt. And on the basis of the facts before, the council found no violation of the Code of Judicial Conduct. That's why I didn't question
Perhaps
you
that
about
was that one, and that's the one, obviously, that's unfortunately the one that's the most memorable. The other parties, one was a gentleman who had a lawyer, and it was a land and a neighborhood dispute. And I don't like to speak bad against these parties, but as these neighborhood disputes go, the zoning enforcement officer, I believe, testified as to some part-time job he had had as a the firefighter assistant or the police assistant, the temporary, those positions that occurred. And most of the complaint, this gentleman had to remove heavy construction equipment from his residential neighborhood lot, and we set up a time period for him to remove his equipment and with a per diem offense. And he repeatedly complained about that afterwards, the decision. But his denial of due process was that I didn't hold the witness in contempt for lying. And that was the long and short of it. Even though both parties were represented by attorneys and no questions were asked or cross-examination ever brought to my attention until afterwards that somehow this witness was allegedly lying about a part-time job he had when he gave his qualifications before he testified. The other...
No, I think we're getting mixed up here.
I don't... Well, I'm telling you about the one.
The one violation of due process was a woman.
All right.
The one prejudicial conduct and decision was a man.
The other two, the women, one was incarcerated and one was not, and I believe, I don't know that the names are there. They would be names that were well-known. They are the parties who had filed, I call them serial complainers or multiple complainers. Both of those women were in connection with the criminal justice system. Both of them complained about every judge that handled their case. All of their complaints were dismissed against, I think one of them was myself and Judge Ronan, and the other one probably goes back even farther to a greater number of judges. The one was that a woman was being held on bond, and the other was a woman who was complaining that she was arrested. I really, there's nothing that a judge can do about that other than make the system work. I believe it would have been someone that did not want to use or apply for accelerated rehabilitation, did not, and I can't remember then what happened to the case. Eventually, I believe another judge resolved it, but the parties had difficulties of their own, is the best thing that I can say about them.
Well, I guess I could accept your explanations. I just wanted to know specifically, not specifically, roundabout way, what the charges were to find out if they were serious. Due process and wrongful imprisonment, those sound bad, but I accept your explanation.
It was the issues of, and it's a very difficult issue, and I think you'll hear and raise that, is the expectations people have of a judge, and here it's just me and you, or me and the party saying it. When you're in a courtroom, there are the judges, there are the prosecutor, there's the public defender, and the defendant and the victim. So there are other parties, each having their say and each having their input. And the pretrial process, where your control is bond, and whether you're held on bond or not held on bond. And we talk about the issue, how difficult it is to use money or bond to control someone. These are parties that are presumed to be innocent. Unfortunately, the more times a party gets arrested, the more delay there is involved. You never get to case 1 if they're just still getting arrested on case 3 or 4. Eventually, these parties do have to have their case heard one way or the other, and it resolved one way or the other, as you find. But you don't have the ability as a judge to punish. It's not, I don't believe you've written it into the statute yet as one of the criteria for setting bond. We certainly have, if a person is at risk to the community, we can use that as a bond revocation or a bond issue hearing. But you're really only talking about money. And unfortunately, there are parties who money is not an object.
Just one more question. What was the time limit, the time barment limit?
I don't know.
Because
I don't know. I don't know if anyone here knows. At least a year, but...
In other words, it took them a year to file this complaint and they got barred? In other words, they
Could
filed it
anyone
over a
willing to
year
help me
later?
out? I believe it's about a year. 2? Could someone help me out from judicial? Yes, Mr. Kolesky is raising, Judge Kolesky is raising, I have a 2.
2
So
years?
1 to 2 years.
They file them after 2 years. That's what they're saying.
As I said, each of the parties involved could have had their own difficulties.
Thank you.
All right, I think you heard Judge Kaplan talk about how there are and his would, of course, repeatedly be time barred.
Thank you. Just for the record, I believe it's 1 year.
Is it, that's what I said.
So, thank you.
But see, now what you really need to do is go look it up in your local law library.
Anything further?
When in doubt, look it up.
Thank you very much.
Is there anyone else?
Thank you. Next is the Honorable Frank H. DeAndrea of Stamford. Good evening, Judge. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please have a seat and welcome.
Thank you.
Where you come from? What city? Oh, Stamford.
Stamford.
It's a nice drive, isn't it, Judge?
It's south from here.
It's south from here. It's good to see you, Your Honor, and welcome. Short calendar is never this long, right? It's good to see you.
I don't do short calendar.
If you have any opening comments for the committee, Your Honor.
Well, they say that the first step on the ladder is to admit it. And my name is Frank DeAndrea, and I'm a judge trial referee. I heard several judges be careful to advise you, the committee, that they actually had formal educations. I went to Fairfield Prep, Yale College, and Harvard Law School, but that's ancient history. I've been on the bench now for 16 years, the last 8 as a judge trial referee, and all but one of those years have been spent in the Stamford-Norwalk Judicial District. I am 78 years old. I'll be 79 in May. My workload is that I work at least 4 days a week, sometimes 5, and I take that Monday off so that I don't have to do short calendar, but I can still try jury cases through Tuesday through Friday. And that's what I do. I try civil cases, jury and court cases. I do pretrials and mediations. I just want to thank the governor for renominating me and asked respectfully this committee to recommend me to the General Assembly for a reappointment. Thank you.
Thank you very much, Judge. You and I have known each other for a long time, right? We don't.
Yes.
They say you don't have old friends; you have friends of long standing. So
Yes.
I consider you a friend of long standing. But let me ask you, since you are a judge trial referee, you indicated that you sit on Tuesdays through Fridays.
Yes.
Is that a result of you making yourself available to the branch, or the branch telling you that they have a need to sit on those days? Which way does it work?
I think it's been my request that to myself and to the branch that I work Tuesday through Friday, because then I don't interrupt a jury trial. They only try jury cases, Tuesday till Friday.
Got it. Okay.
Monday is just assigned a short calendar day.
So because of your desire to try the cases, you need to make that commitment
I don't
of
even try court cases on Mondays,
right.
really.
But you need to make that commitment of the Tuesday
Yes.
through Friday block
Yeah.
for consistency of the trials.
Yes.
Okay. Let me just ask you, since you do civil trials, what impact, if any, have you seen as a judge trial referee with respect to the budget crunch, if you will, that the state is involved in on the trial of civil matters, if any?
Well, of course, I have to be honest and say I have not noticed an impact on myself or the civil side in Stamford. We have an excellent case flow management process. The clerk's office is good. I haven't really noticed a problem specifically from my chambers because of the budget crisis we have, although I'm concerned about it. I'm concerned about the closing of some libraries. My biggest challenge is to make sure I know how to e-file and use the computer, because
The lawyers, too, Your Honor.
computers a long time ago.
Okay. And maybe that's just because the branch has tried to protect judges from the effects of many of the cuts, but you probably wouldn't run into as many problems with lack of court monitors or...
No, I have not, nor court marshals. Well, I don't see a court marshal in my courtroom, ever, except when they're leading the jury back to deliver their verdict. But there aren't enough marshals to put in my civil courtroom, in the courtroom that I sit in.
When you first went onto the bench in civil cases, were there marshals in the courtrooms?
Yes.
When did that stop for the most part?
Well, it's been, I don't know, maybe 2 or 3 years. They got progressively thinner in their appearances in the civil courtrooms until now. We don't see them hardly at all.
Okay. Well, thank you. I don't have any further questions. I just wanted to thank you for your time on the bench, Judge, and you have a long history and tradition of public service long before you ever went onto the bench. So I want to thank you for that as well, and appreciate your patience here today and the patience of your lovely wife being here today. And I wish you all the best in your next term. Are there other questions? Representative Fox, where are you from?
Thank you, Mr. Chairman, and it's good to see you here, Judge DeAndrea, and congratulations on your reappointment. I too have known you for a long time, and in reading through your questionnaire, it's really remarkable all of the public service that you've engaged in before your time on the bench. You've held a number of positions in the city of Stamford, and have had a great and profound impact on our community. And now you're doing a great job for the state of Connecticut as a judge, and as you now enter another term. One of the questions I have, because I know that in Stamford you are much sought after as a mediator through the court annex mediation. I know you do some of that. And maybe if you could tell the members of the committee your experiences with that program. Has it been beneficial? I know we had some other judges also comment on that.
I don't do as much mediation as some of the other judges. I do a lot of pretrials. When I'm not trying a case, I have at least 1 or 2 pretrials every day, and then I can go back to writing the present decision that I have before me for a court trial. Mediation is, in my experience, has been 50-50 successful. Some people don't really come to mediation wanting to settle. They think they do, but they take a contentious view the minute they walk in, and it's hard sometimes to part from those ways. Sometimes it's helpful to bring the clients in individually and talk to them directly with their lawyers about the case. But I'm not suggesting it should ever be stopped. In fact, we should have more of it. And I think that in time, people will get used to the fact that I'm here to settle this case and resolve it. But you have other factors, always other issues that come into play that make it difficult to settle even a case that you're trying to mediate settlement in.
Well, I do know that your name is one of the ones that oftentimes both sides can agree on as somebody who they feel will be fair in hearing their dispute. So.
I like to do it, and I just wish I could be more successful than I am in bringing the parties together.
So congratulations once again.
Thank you.
Anything further? Representative O'Neill?
You indicated that you do pre-trials as well as trials. I'm just wondering, approximately, how many trials do you think you preside at in a given year?
Well, I can tell you because in preparation for this hearing, I reviewed my binders. I keep a binder for jury trials and court trials for all the 16 years that I've been on the bench. I have tried 108 jury trials to verdict and 163 court trials to decision. I don't know how that breaks down in a matter of how many a week or a day or a year, but that's I do a lot of them.
I didn't keep track of the numbers exactly as you were reciting them, but that sounds like about 230 trials during the
270, I think. 163 and 108.
I thought it was 216. Okay, 263. So without doing the arithmetic exactly, it's probably 20 cases. It sounds like around 20 or 25 cases per year. So that during the course of that, spread out over that time, which does sound like a lot of cases. And I noticed that Representative Gonzalez has returned to the room, but you also, in all of those trials, have never had anyone file a complaint with the Judicial Review Council.
I never have.
And you've obviously had to make hundreds of rulings as well as a couple of hundred decisions at the end of these cases. So that's a remarkable, given that so many people have complaints filed against them, remarkable testament to the way that you're able to present things to people. And as far as the mediation is concerned, I don't know if you had any going on yesterday, but I actually went to a settlement conference, and the fact that people drove through yesterday's weather to get to the table to negotiate suggested that they were ready to settle. We were ready to ready to make a decision. And if they're looking for an excuse not to go, then probably they're not ready to settle, no matter what kinds of offers were being placed on the table. So thank you again for your service to the state, and wish you well.
Thank you, Representative O'Neill.
Are there any other questions from members of the committee? Okay, seeing none, thank you, Judge DeAndrea. Have a safe trip back.
Flex.
Next is the Honorable Joseph Q. Koletsky. Good afternoon or evening, Your Honor.
As you prefer, evening or afternoon.
If you could raise your right hand. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated.
Thank you.
And if you have an opening statement.
Well, as beyond thanking the governor for the renomination to this fourth term, and as fascinated as I am with my career to date, beyond mentioning that I tried cases for 23 years in the Navy in a private law firm and have been on the bench since 1985, during which time I've done everything that a judge can do, the last 10 years being really nothing but large jury, civil, and criminal trials, and the last several years, Part A criminal in Hartford. Probably more than a dozen capital felonies. And I'd be happy to answer your questions.
Any questions from members of the committee? Well, Your Honor, since the chairs are not here, I know that they've asked a series of questions regarding impact or possible impact of the cuts to the judicial branch, and perhaps if you could talk about your own experiences, if you've seen any.
Certainly. Well, most dramatically, Part A criminal trials, the murders, the rapes, generally get the marshals. And as recently as 3 or 4 months ago, I had to shut a murder case down. One of my colleagues had to shut a murder case down because another colleague was taking a verdict, and the marshals from our courtrooms had to go and reinforce the marshals in the courtroom that was about to deliver the verdict. So we had our 15-man juries, 15-person juries, sitting there for a couple of hours because we didn't have enough marshals. It's a very serious shortage.
And how long do you find the jury selection process takes in a case like that?
I have picked 5, 6 death-qualified juries, and believe it or not, I think I hold the speed record of 6 weeks.
Yeah.
Now, I don't think there's another state in the union where that would produce anything but a shock and awe of horror, but it can take forever. Poor Judge Blue in New Haven is, I mean, Lord knows how long that's going to be. I did one in 6 weeks with 2 defendants and death-qualified jury, so everybody had 120 challenges, 240 challenges, 120 challenges altogether. And we still did it in 6 weeks.
Are there any?
But I should just say, it's not uncommon to spend more time picking the jury than it is from opening statement to argument, to verdict.
And that's in every case almost, right? Not just
every case.
Not just a capital case. Are there any other questions? Representative Gonzalez?
Thank you. Good afternoon, Judge.
Good afternoon.
I was looking at you presiding in Lafayette Street in Hartford.
I'm sitting in Lafayette.
You're sitting?
In Hartford, yes.
And how you like that, Hartford?
Very much.
Very much?
Lovely city.
Okay. How do you think about discrimination in the court, knowing that it's a lot of minority people that go to Lafayette, a lot of African Americans and Latinos?
There is nothing so distressing. I can't count the number of murder trials I've presided over, and it seems always to be a defendant of color, and it's very distressing. But in terms of specific acts of discrimination in a courtroom where I'm presiding, if I become aware of it, I would do something, but I have not. I'm happy to say become aware of any specific instance. But it's not, something's wrong if all the defendants I'm looking at are not representative of all the population of the state.
Okay. Thank you. Thank you.
Representative O'Neill?
Thank you. I had a couple of questions, and now I've got an extra one. With respect to the proposition that perhaps we could avoid shutting down law libraries by terminating temporarily, presumably, the services for some of those libraries, the updating of various legal treatises and that sort of thing, versus shutting down the library, which is we had this discussion over in the Appropriations Committee a couple of weeks ago. I'm just wondering, how do you feel about the idea of that, shutting the services off, not updating the treatises and so forth?
Law books without the update services are the functional equivalent of shuttering the doors of the library, in my opinion. Mm-hmm. If you can't get the latest law, then there's no sense in going to the library at all. Okay. So I think, I don't know the specifics of the proposal you're talking about, but if the proposal was go statewide to shut down all the statewide updates,
No, actually, Your Honor, I think the proposal that was coming from some folks outside the system, but one was, I think, a retired judicial librarian, and the other one was someone who's I think, president of the Connecticut Association of Law Librarians or something like that. It was somebody outside, not a member of the Judicial Branch, had said that in the past there had been, and I think I remember this, at least in certain libraries, not across the entire state, where certain updates just weren't being purchased, and that's how you could save most of the money. If you shut the libraries down, actually, that's how you would save the money, because the librarians are all going to continue to be posted to some other assignment, not that law library, so not going to save the salaries, apparently. And the books, they're not going to rent that space out to people and get rid of all the books. They're just going to leave them there, but apparently lock the doors. So what I understood the proposal to be would be to just in those courthouses where the library, instead of being shut down, would just not be updated, and that's how they would save all the money. That's what was being contemplated or suggested as an alternative to shutting the libraries.
Well, as long ago as I was in law school, I remember the unforgivable sin was failing to shepherdize a case. Right. And I see you're nodding, and
yep.
Because you're obviously a lot closer to law school than I.
Well, it's very embarrassing when you cite a case and then someone tells you it was just overruled. That
Indeed. Would you like to see my scars?
Yeah. We can compare. The other question that I was wondering about in terms of the death qualified juries, you mentioned you've done 6 of them and may hold a speed record. Is there anything that you can think of that we could do that would not violate the constitutional right to have individual voir dire that might move things along more quickly?
Well, the constitutional I don't want to give an opinion on a case that hasn't arisen yet. The constitutional provision may not require what we now have. Mm-hmm. Certainly the legislative enactment of the constitutional provision does, I think, require what we now have. Assuming arguendo that the Constitution only requires the right to individually question, which is what it says, and if then a legislative adjustment of that enactment could really speed up voir dire. I see lots and lots of voir dire, and I see a lot of time wasted, not on purpose. If counsel don't ask the same questions of every venire person, then they're setting themselves up for a Batson challenge, a claim that they're discriminating against a person against whom they've exercised a peremptory challenge. So I can remember one jury, a murder jury, years ago. The defense counsel was Attorney Jim Wade, and the prosecutor was now Chief State's Attorney Kevin Kane. And we picked 15 people in 4 days. And that was a voir dire that took longer than federal court, but there were at least half a dozen people who I suspect would have been seated in federal court who really shouldn't have been on that jury. But it's very rare to see it done that well.
So